Welcome and thank you for joining us for this webinar on the building permit process back to basics, held as part of the Victorian Building Authority's Practitioner Education Series. Before we start, I'd like to begin by acknowledging the traditional custodians of the land on which we meet today and pay respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples attending this session today. We appreciate their love of and for country, and we respect their care and sustainability for this amazing country we call home. As Victoria's building regulator, the VBA is committed to ensuring a confident, thriving industry. Today, you'll hear from Christian Williams, who is our Senior Technical Advisor for the Tech and Reg building team. Before we begin, this session is being recorded and a link to the presentation will be made available on our website along with previous webinars. We have set time aside at the end of the presentation for your questions. However, I'd like to draw your attention to the Q&A icon at the bottom of the screen and encourage you to type your questions there throughout the presentation. We also have some knowledgeable people in the background who will address as many of your questions as time allows. What we don't get through the session, we will send you an answer to the email you provided or send an overall FAQ to all attendees. There's also a chat function available throughout the presentation. We ask that any comments made in this chat function is limited to constructive feedback and appreciate your professionalism in this regard. Your feedback is very important to us, so after the presentation, you'll receive a link to a short survey. We value your feedback and you wish to provide about this presentation or any other suggested future webinar topics. Today's presentation, Back to Basics, will be focusing on some key areas of the building permit process that have been identified as requiring improvement or which have been identified through intelligence gathered by the VBA from our building audit program, through complaints and statutory referrals, through our proactive inspection program, or through technical inquiries. We'll be discussing the very basics of the application process, documentation requirements for building permits, some of the requirements for issuing building permits, and the inspection process. This will include some insights from intelligence gathered by the VBA to assist practitioners in identifying key areas for improvement. Now over to Christian for the presentation.
Thanks, Dominic, and good afternoon, everyone. My name's Christian Williams, and I'll be presenting the session today. The first part of this session will focus on some of the key areas of the building permit application process, including the appointment of private building surveyors, lodgement of documents with council, details required for building permit applications, and terminating the appointment of a private building surveyor. Throughout this presentation, reference will be made to the Act, the regulations, and the NCC. Please note that these are references to the Building Act 1993, Building Regulations 2018, and the National Construction Code, unless otherwise stated. In addition, where reference is made to the RBS, this means relevant building surveyor. Again, please feel free to ask questions at any time during the session via the Q&A function at the bottom of your screen. The job of a registered building surveyor is to ensure that building work complies with the Act, the regulations, and National Construction Code. They also issue building permits to allow building work to commence. Building surveyors carry out inspections to ensure building work is being undertaken correctly. They also issue occupancy permits or certificates of final inspection when the work is complete. A registered building surveyor is authorised to carry out the functions under Section 76 of the Building Act and any other functions conferred upon building surveyors, including assess building permit applications for compliance with the Building Act regulations and NCC, issue building permits, occupancy permits and certificates of final inspection, conduct building inspections at mandatory notification stages, and take enforcement action. There are two types of building surveyor: private building surveyors and municipal building surveyors, or the building surveyor at the local council. An applicant for a building permit can choose whether they use a municipal or private building surveyor, and only one building surveyor can be appointed for the building work. However, there are different processes for appointing a building surveyor. If you decide to engage a municipal building surveyor, you do not need to formally appoint them, as Section 78 of the Act applies only to private building surveyors. Instead, an application for building permit must be made to the local council. If you decide to engage a private building surveyor, they must be formally appointed. An appointment occurs at the point of acceptance of an offer by the owner or their agent to enter into a contractual arrangement with the private building surveyor. Only an owner or their agent may appoint a private building surveyor. It is important to note that where the work is domestic building work, the builder cannot appoint the building surveyor. This applies even where the builder has been authorised by the owner to act as an agent on their behalf for the application. Technically, a private building surveyor must be appointed prior to an application for a building permit being made. This is because Section 17 of the Building Act provides an application for a building permit may be made to a private building surveyor that has been appointed under Part 6 of the Act. Once a private building surveyor has been appointed, they become the relevant building surveyor, or the RBS, and they remain the RBS for that building work unless their appointment is terminated or their functions transferred to another building surveyor. Under Section 80 and Section 80A of the Act, a private building surveyor must, within 7 days of accepting an appointment, notify the relevant council in writing of that appointment. It is noted that this requirement is sometimes being missed, or the 7-day notification period is not being met by some private building surveyors. The VBA urged private building surveyors to ensure that the notification of appointment is submitted to council within the 7-day time frame. Otherwise, this can lead to problems such as dual appointments. For those of you who are not familiar with the term dual appointment, this is in reference to where two private building surveyors have been appointed for the same building work. Section 30 of the Act requires that the relevant building surveyor submit a copy of the building permit, plans and any other documents lodged with the application and the documents prescribed under Regulation 44 of the Building Regulations within 7 days of issuing the building permit. This must also be accompanied by the VBA approved checklist made under Section 30A of the Act, which is available for download from the VBA website. The VBA have been advised by councils that some building surveyors are either not lodging within the 7-day time period or are not meeting this requirement appropriately, as they've been marking up the Section 30A checklist and are not lodging all the documents specified, and noting some application documents on the checklist and not lodging all these documents, or are not filling out all required parts of the checklist. The VBA asks that building surveyors please be diligent where it comes to Section 30 lodgements and Section 30A checklists, as this can have significant ramifications down the track for the owner, the RBS and the council, especially if the RBS is no longer registered or in business. For example, where an extension or renovation is proposed and documents are sourced by from council, however, as all relevant documents were not lodged by the original RBS, the new building surveyor is unable to determine compliance of certain parts of the building work. This could also impose unnecessary costs on the building owner to have these parts of the building inspected and/or further evidence sourced to demonstrate compliance. In accordance with Section 17 of the Building Act, an application for a building permit may be made to a private building surveyor or a private municipal building surveyor or a private building surveyor under Part 6. An application for a building permit must be made in the form of Form 1, must include the prescribed information under Division 2 of Part 4 of the regulations and must be accompanied by the required fees. It's not considered to be a full application unless all these items have been provided to the relevant building surveyor. An application for building permit can be made by the owner or their agent. However, where the application is being made by the owner's agent, the agent must be authorised in writing to act on behalf of the owner. Evidence of authorisation should be provided to the relevant building surveyor along with the application documents. Application should also include the correct cost of the building work, including labour and materials, and any other information that the relevant building surveyor may require in order to estimate and confirm the cost of the work. This could simply be the builder's contract price, or could require some other information, such as, for example, where the owner has purchased some of the items for the building or has carried out some of the work. All cost details are required for the purposes of calculating the building permit levy. To avoid delays in issuing of building permits, the VBA recommend that practitioners who are acting as agents for the owner ensure that the details on the application form are all filled out correctly. This includes the owner's details. It is noted that consent from all relevant owners is required to make an application. Therefore, if a practitioner is acting as an agent, they should also ensure that all relevant owners have signed the authorisation to act on their behalf. Ideally, a building surveyor should remain involved for the entire duration of a building project. However, sometimes a property owner needs or wishes to change a building surveyor before a project has begun or it is complete. In accordance with Section 681 of the Building Act, property owners cannot terminate the appointment of a building surveyor without the consent of the VBA. To apply to terminate or change a building surveyor, an application form must be completed along with the required information and documentation. The application will be considered in accordance with VBA guidelines and the outcome will be advised. Confirmation that the preferred building surveyor is willing to accept the appointment must also be provided before we can grant consent. The VBA will only accept an application to terminate the appointment of a private building surveyor in limited circumstances. This is because when implementing building standards, a building surveyor may need to make difficult decisions that conflict with the wishes of a builder or an owner. Disagreeing with the decision of the building surveyor is not sufficient grounds for termination. If you disagree with the decision of a building surveyor, you can appeal to the Building Appeals Board. A request to terminate will not be granted if there's a dispute about enforcement action. It's important to note that only the appointment of a private building surveyor can be terminated. You cannot terminate the appointment of a municipal building surveyor. Where an application for a building permit has been made to a council, the owner is locked in with council for the duration of the project. Section 80C of the Act allows a private building surveyor to transfer their functions to another registered building surveyor. This is to enable the project to continue, for example, where the private building surveyor wants to go on holiday. The transfer of functions must be initiated by the transferring building surveyor and is contingent on the acceptance of the person who appointed the private building surveyor and acceptance by the new relevant building surveyor to take on the functions. The transfer is not effected unless the transfer is done through the VBA approved form and sent to the VBA by the new relevant building surveyor with all consents given. Again, only the functions of a private building surveyor can be transferred under Section 80C of the Act. The functions of a municipal building surveyor cannot be transferred. However, a municipal building surveyor may accept a transfer of functions from the transferring building surveyor. The next part of the session will focus on some of the basic documentation requirements. This includes the requirements for building permit applications. We'll also be providing some high-level insights from our building audit program, outlining where the documentation for building permits appear to be most insufficient. The VBA encourages building surveyors to exercise due diligence when accepting documentation in relation to building permit applications. Designers should also be aware that it is important that the information is of sufficient quality to enable assessment for compliance with the Act regulations, NCC, and reference Australian standards. Section 24(1)(a) of the Act states that the RBS must not issue a building permit unless he or she is satisfied that the building work and the building permit will comply with the Act and the regulations. In order to do this, the RBS must assess and determine the information contained within a building permit application demonstrates compliance, and the building work, if constructed in accordance with the approved documentation, will comply. Part 4, Division 2 of the Building Regulations establishes the minimum documentation requirements for an application for a building permit. The minimum documentation required to accompany a building permit application for a permit to construct or alter a building is set out in Regulation 25, whilst Regulation 26 provides the minimum documentation to accompany a building permit application for a permit to demolish or remove a building. It is important to note that Regulation 27 specifies that the RBS may exempt an application for a building permit from any of the requirements under Regulation 25 and 26. If the RBS has considered any of the requirements are not relevant to demonstrate the building works will comply. An example of this could be where the RBS receives an application for proposed internal alterations. The RBS may determine that is not relevant to the allotment plan to show the distance to the nearest intersecting street as required by Regulation 25(2)(b), as it has nothing to do with an internal alteration. Lastly, Reg 28 provides the minimum application documentation to accompany a building permit application where a swimming pool or spa is proposed. Further to this, Regulation 29 stipulates that the RBS may require all or any of the information set out in Regulation 29 to be submitted in relation to an application for building permit. For example, the RBS may request documentary evidence to support the use of a material, product, form of construction, or design in a form referred to in clause A5.1 of the NCC or A5.2 of the NCC as required under Regulation 29(b). One of the major considerations for building permits is the approved drawings. The designer, builder, owner, or their agent should ensure that the RBS has the most recent set of drawings to assess for a building permit application. When undertaking building work, practitioners need to ensure that the documentation they are using and or providing are the applicable versions and have evidence of approval stamped and endorsed on them by the RBS. The VBA recommend that building surveyors provide a list of approved documents as an annexure to the Form 2 or building permit. This will assist in ensuring the owner of the allotment and the builder named in the building permit and any other relevant parties to the building work are aware of the current approved documentation. Where there are variations to the building work, approved drawings or other documents, the documentation will again need to be submitted to the RBS for approval prior to undertaking the building work. This may require the issue of an amendment to a building permit, an additional stage building permit, or a new building permit, depending on the extent of the variation. Whilst we're on the topic of building permit applications, the VBA would like to remind practitioners of the timeframe requirements stipulated in Regulation 35(1) for the RBS to decide an application for a building permit. For an application for a Class 1 or 10 building, the RBS must decide within 10 business days after the relevant day, or in any other case within 15 business days after the relevant day. Regulation 35(2) defines relevant day as the day all report and consents are received by the RBS, or the day that they must be supplied to the RBS. Furthermore, Section 19(3) of the Act stipulates that the RBS is taken to have refused a building permit if the application is not decided within the prescribed time. The graph which you see in this slide was obtained from the the VBA Building Surveyor Audit Program report between January 2021 and December 2021, which is available from our website and outlines some of the findings due to insufficient documentation which form part of building permits. From this graph, it can be observed that 82% of audits demonstrated that there was insufficient information to check compliance with performance requirement FP 1.4 for weatherproofing. The report indicates that this was a result of there not being a performance solution completed for any external walls, there not being a performance solution completed for all external wall systems, the evidence of suitability being relied upon was not appropriately assessed. For example, limitations and conditions were not met of a code mark, or a code mark or the like was relied upon by the RBS. They did not undertake a determination as required under Regulation 38. In addition, 52% of the audits demonstrated there was insufficient information to check compliance for protection of openings, and 46% of audits identified that insufficient information was provided to check compliance for firefighting equipment. In summary, provisions for escape had the highest compliance rates. They had 89% that had compliance achieved. We encourage all practitioners, especially those involved in Class 2 to 9 buildings, to have a look at this audit report in further detail to determine where further improvements can be made. Regulation 41 provides a requirement for provision and display of building permit information. Sub-Regulation 1 of Regulation 41 stipulates that the builder named in the building permit must ensure that the following documents are available for inspection at the allotment: a copy of the building permit and a copy of each document given to the builder under Regulation 40, which includes plans, specifications, and other documents, except for computations or reports lodged with the application with evidence of approval stamped and endorsed on them. Please note that the documents located at the allotment must be in hard copy and not in electronic format. This is to ensure that all persons needing to access the documents on site have the ability to access them. Furthermore, we suggest keeping the documents in a prominent position at the site where it cannot be adversely affected by the weather, but is also easily accessible to persons needing to access the documents. The intent of this regulation is that the approved documents are available on site at all times for those who need to access them, such as building surveyors or other regulatory authorities. Builders should ensure that the current applicable version approved set of documents are the version that is left on site. Sub-Regulation 2 of Regulation 41 requires the builder to display registration numbers and contact details of the builder and relevant building surveyor, the building permit number and the date of issue of the permit. They need to be put on the allotment in a conspicuous position accessible to the public. This must be before the commencement of any building work on the allotment. The intent of this regulation is to ensure that the contact details of the builder and relevant building surveyor are available in case of any issues that may arise in relation to the building site or the building work. Penalties apply to breaches of Regulation 41, and infringement notices can be issued by the local council. For every building permit application, evidence of suitability will be required to be submitted to the RBS to support the use of a particular design, material, product, etc. The requirements for the type of evidence that can be submitted for a building permit come under the Building Regulations 2018 and Part A 5.2 of the NCC. There are a number of types of evidence that are considered acceptable, such as code mark certificates, accreditation certificates, such as in Victoria from the Building Regulations Advisory Committee or the BRAC, a certificate from another certification body, a report from another accredited testing laboratory, a certificate or report from a professional engineer or other appropriately qualified person, such as in Victoria, a Regulation 126 certificate from an endorsed building engineer, any other form of documentary evidence, such as, but not limited to, a product technical statement. Evidence to support a calculation method complies with an ABCB protocol. Under the National Construction Code from the 1st of July 2021, compliance with clause A2.24 is required, meaning all performance solutions must follow the process of preparing a performance-based design brief and a final report. The relevant building surveyor should not be involved in the performance-based design brief, as they must have no involvement in the design of the building. The use of a code mark certificate as evidence of compliance with the relevant performance requirements is used in support of a performance solution. The Australian Building Codes Board, or ABCB, have recently released some guidance on their website in relation to clause A2.24 of the NCC and the use of code mark certificates. The ABCB state that the conformity body that issues code mark certificates uses a process that's equivalent to the process set out in clause A2.24. Therefore, relying upon a code mark certificate, a practitioner need not undertake the process in A2.24 again. However, it's important to note that a code mark certificate may only certify some of the performance requirements, and in these cases, the code mark certificate on its own may not be sufficient to comply with A2.24, and the process therefore needs to be undertaken. The relevant building surveyor must check any limitations or exclusions set out in the code mark certificate against the proposed design and the use of the building to ensure that the conditions and limitations have been met. This will form the basis of the RBS's determination that the performance solution complies with the relevant performance requirements as required under Regulation 38. It's important to note that the process undertaken by the conformity body for code mark certification is different to that of the Building Regulations Advisory Committee. Therefore, the process under A2.24 of the NCC must still be undertaken where a BRAC certificate is being used as evidence to support a performance solution. Where a performance solution relates to a fire safety performance requirement, the RBS must not determine that the performance solution complies unless they hold a specific qualification, rely on a report from the Chief Officer, rely on a code mark or BRAC certificate, or a certificate from an engineer or other building surveyor that does hold the qualification as required under Regulation 121. Despite relying on one of these provisions, the RBS must still make a determination in accordance with Regulation 38. This is because the RBS must record the basis on which they have determined that the performance solution complied with the relevant performance requirements. This part of the session will outline some of the basics for building permits. This will include basic requirements for building permit issue, basic requirements for protection works process, requirements for enforcement, such as directions to fix and building orders, including referral to the VBA. A building permit can only be issued when a building surveyor is satisfied the proposed building work meets the minimum standards of safety and amenity as set out in the Act, the regulations and NCC. A building surveyor, before issuing a building permit, must take into consideration the further limitations specified within Part 3, Section 24A and 24B of the Act. The building surveyor must not issue a building permit in relation to building work unless they are satisfied that the requirements of Section 24A are met, in that the building work is to be carried out by a builder who is specified under Section 24B. The builder is named in the building permit. In the case of building work carried out under major domestic building contract for the cost of building work $10,000 or more, if the cost of the building work exceeds the prescribed amount of $16,000, the following names are identical: the person who's named as the builder in the contract, and the name of the person specified as the builder in the certificate of insurance. The major domestic building contract was entered into by a person entitled to do so under Section 29 of the Domestic Building Contracts Act 1995. And in the case of a builder who's a body corporate, there is specified in the building permit the name of the natural person whom directions, notices and orders under the Act directed to the body corporate can be served. For the purposes of Section 24B of the Act, where the cost of the building work does not exceed $10,000, anyone can carry out the building work, as there are no registration requirements where the work is less than this amount. Where the building work is domestic building work more than $10,000 carried out under a major domestic building contract, the builder must be the builder who entered into the contract and whose registration authorises them to carry out the work. Regulation 271 of the building regulations states that the persons authorised to carry out domestic building work are those practitioners referenced under Schedule 12 of the building regulations. These are domestic builders only, being work on Class 1, 2 and 4 parts of a building and associated Class 10 buildings. Commercial builders cannot carry out work on these buildings where the cost of work exceeds $10,000. Regulation 36A requires the relevant building surveyor to examine an extract of the major domestic building contract and a copy of the certificate of insurance in order to be satisfied the builder can undertake domestic building work. Where the work is not domestic building work, but the cost of work is more than $10,000, the builder is required to be a registered practitioner. They could also be the owner, the architect, or an engineer. This work is considered to be commercial building work, which is work on Class 3, 5 to 9 buildings and associated Class 10 buildings. It is noted that the type of practitioner that can carry out this type of work is not specifically mentioned. Therefore, in these cases, it would be at the discretion of the relevant building surveyor as to whether the practitioner has the appropriate knowledge and experience to undertake the work. The most appropriate practitioners to carry out this type of work are commercial builders that are registered in a class that's applicable to the work. However, this does not mean that the permit cannot be issued to other practitioners as the builder. The VBA recommend that building surveyors err on the side of caution if considering to issue building permits to builders with other registrations. As if something goes wrong, the building surveyor could be held accountable under the Building Surveyor's Code of Conduct. A building permit must be issued in the form of Form 2 and must include the prescribed details on the form. Building permits may be standalone or may be staged. Each stage permit is treated as a building permit in its own right. However, the commencement and completion dates for the building work apply from the date of the issue from the first permit. The RBS must specify in the permit whether an occupancy permit or certificate of final inspection is required, having regard to Section 21 of the Act and Regulation 185 of the regulations. While this presentation is focused on building permits, it's also important to note that an occupancy permit or certificate of final inspection is not evidence that the building work complies with the Act or the regulations. An occupancy permit is evidence that the building is fit for occupation, and a certificate of final inspection is evidence that the building work has reached completion under the building permit. Building work must not be carried out unless a building permit is issued and enforced under Section 16 of the Act, unless an exemption otherwise applies. A building permit remains in force for a prescribed period in which the building work must commence and must be completed. This is to ensure that the building work does not remain unfinished or is potentially unsafe or unsightly for a prolonged period. The RBS must ensure that the appropriate dates are specified on the building permit. If the building work is not commenced or is not completed within the time limits, the building permit will lapse pursuant to Regulation 55. Any building work carried out after a building permit has lapsed will be in breach of the Building Act. An extension of time may be granted by the RBS before the permit lapses. All building work must commence within 12 months of permit issue, except for the re-erection of a Class 1 or 10 building, which must commence within 6 months. The building work must be completed from the date of issue of the building permit as follows. For a Class 1 or 10 building within 24 months, re-erection of any building within 12 months, other building work not mentioned and in relation to Class 2 to 9 buildings, other than a re-erection, must be completed within 36 months. A swimming pool or associated barrier or safety equipment not being carried out concurrently with other building work on the same allotment must be completed within 6 months after the building work commences, or if concurrent with other building work, must be completed in the same timeframes as that work. If the RBS has not carried out an inspection at the first mandatory notification stage, the RBS must notify the applicant prior to 30 days before the end of the commencement date that the permit will lapse under Regulation 56, and prior to 30 days before the completion date that the permit will lapse under Regulation 57. If a building permit has lapsed, it cannot be extended by the RBS. Once a building permit has lapsed, a new permit must be issued in order for the building work to continue. However, where inspections have been approved at required mandatory stages and there is no further work to be carried out, a final inspection may be conducted and an occupancy permit or certificate of final inspection issued without the need for a further building permit. Section 41A of the Interpretation of Legislation Act allows the RBS to amend or revoke a permit, as this provision applies to powers granted under the Building Act. Amendments are made at the request of or on behalf of the owner, or if the RBS considers that it's necessary. When amending a building permit, the RBS must follow the same process required for an application for a new building permit, including Section 30B and Schedule 2 of the Act. The RBS should not amend a building permit unless they are satisfied it's more appropriate to amend a building permit than to issue a new one. Some circumstances where it may be appropriate are for administrative errors, minor design changes, change of the owner, building practitioner, architect or engineer, or extending the commencement or completion dates of the building permit. The Act does not require the relevant building surveyor to recalculate the cost of the building work when amending a building permit. However, as per Section 205KA of the Act, if a revised cost of the building work exceeds $15,625, the applicant for the amendment must inform the VBA, and written notice must be provided within 28 days after becoming aware of the increase in costs. The RBS should make the applicant aware of their responsibility to notify the VBA when amending the building permit. Under Regulation 111, the protection work must be carried out before or during the carrying out of building work by the owner, where the RBS has determined that it's required. Some people are of the opinion that where there's work being carried out on or near the boundary of an adjoining property, or where the builder needs to access the adjoining site to carry out some of the work, that this automatically means that protection work is required, where this is not actually the case. Protection work is only required where the RBS considers that there could be damage to the adjoining property by the carrying out of the building work. Adjoining property is a defined term under the Building Act and specifies the land. Therefore, it's possible it could include anything on the owner's land that would be at risk of damage from the building work. For example, the structural capacity of the adjoining soil, driveways, trees, and any buildings, etc. Regulation 112 also specifies what the RBS must consider when determining protection work is required. The RBS may determine protection work is required prior to the issue of a building permit or at any time during the carrying out of the building work. The determination must be in the form of Form 6. A building permit may still be issued even though the protection work process has not been yet finalised. The building work can still be carried out on other parts of the site. However, the building work that gave rise to the requirement for the protection work cannot be carried out until such a time that the protection work requirements have been met. The RBS's only responsibility in the process is to determine that protection work is required in the first instance and to make a determination on the appropriateness of the work once they have received notice in Form 8 for a request for further information or a disagreement to the protection work. The RBS has no further obligation in the process, and where there is a dispute in relation to the protection works process, the owner or their agent must make an application to the Building Appeals Board. Furthermore, the RBS cannot take enforcement action, such as, for example, a stop work order. This is because enforcement is only applicable to building work and not to protection work. Quite often, a builder or designer may act as an agent for the owner. In these cases, practitioners should make themselves aware of the requirements for protection work. The owner or the agent must provide the documents required under Regulation 113. Along with the Form 7 and 8, there are other documents to be provided. For example, plans and specifications of the building work and protection work, an allotment plan, a copy of the Form 6 determination, and the VBA approved statement, which is available for download via the VBA website. The owner or the agent in company with the adjoining owner or their agent are also required to carry out a survey of the adjoining property and record in writing or by other means all existing cracks and defects. This is typically known as a dilapidation report. This report must be signed or otherwise acknowledged as an agreed record of the condition of the adjoining property. The owner or their agent is also required to arrange insurance cover from damage to the adjoining property during the carrying out of the building work and for a period of 12 months after the building work is complete. The type of insurance policy that is typically used for protection work is a public liability policy. Many builders already carry this type of insurance policy. However, typically the builder's public liability policy only covers the site they're working on. Therefore, the builder will need to go back to the insurance company and ask for an addendum to their policy to cover the adjoining property. At some point during the building permit process, it may become necessary for the RBS to take enforcement action. This could be in the form of a direction to fix building work under Part 4 of the Building Act, or a building notice or building order under Part 8 of the Act. The RBS may issue a direction to fix to the builder if after inspection they reasonably believe that the building work fails to comply with the Act, the regulations or the building permit. Where a written direction to fix is issued, it must be in the approved form and specify the date for compliance to be achieved. On request, the RBS may grant an extension to that date. According to Section 37K2 of the Act, the RBS must refer a written direction to fix to the VBA if a builder fails to comply. The RBS needs to notify the VBA within 7 days after the final date for compliance specified in the direction. After we've been notified of the direction, the RBS is still responsible for ensuring compliance is achieved. The RBS should consider further enforcement action, such as the issue of a building notice or building order. When a direction to notification is received by the VBA, we first assess its enforceability. If the requirements are not met, we may not be able to support enforcement action with a disciplinary response. If we're unable to take further action on the notification, we will write to the RBS explaining why it's not enforceable. A building order must be served in the prescribed form under Schedule 4 of the regulations and must specify the date for compliance to be achieved. Under Section 115 of the Act, if a person fails to comply with a building order made by a private building surveyor, they must refer the matter to the VBA. Once a building order has been referred to the VBA, the RBS must then take no further action regarding the matter. The VBA can only accept a building order served under Section 111 of the Act, Section 112 of the Act, and Section 113 of the Act. According to Section 115 of the Act, the RBS must refer the building order to the VBA within 14 days after the final date for compliance specified in the building order. Once all the correct information is received by the VBA, the building order will be assessed. During the assessment, the VBA take into account applicable legislation, regulations, and specific requirements that make the order enforceable. If we're unable to take further action on the referral, we will again write to the RBS explaining why the referral is unenforceable. Only valid building orders referred to the VBA will be considered for enforcement. And to be enforceable, all building notices and orders need to comply with Division 2 of Part 12 of the building regulations and include the prescribed information and be in the correct prescribed form. For a more detailed presentation on enforcement, please refer to the previous VBA Practitioner Education Series session presented by Anita Dorfer-Mahanich, available on our website. For further information regarding notification of a non-compliance with the direction to fix or a referral of a building order, please also refer to the VBA website. This will be the final part of our session, and we'll discuss the basics for inspections under building permits. This will include mandatory notification stages for building work and some insights from the VBA statutory referrals team on breaches of the mandatory notification requirements, which have been referred to the VBA by the relevant building surveyor. We'll also discuss some of the basic mandatory inspection requirements. Mandatory notification stages are critical stages when the building work must be inspected, allowing inspection of the core components of the building work to ensure compliance with the Act, regulations, and the building permit. Inspections occur at certain stages of the building work, as set out in Regulations 167, 168, 169, and 172. At each mandatory notification stage, an inspection must occur in accordance with Regulation 171. For construction of a new building or alterations to an existing building, the prescribed stages are before placing a footing, before pouring an in situ reinforced concrete member, completion of framework, inspection of fire and smoke resisting elements as required under Reg 172, and final on completion of all building work. Reg 172 requires additional mandatory inspections in each story of a Class 2, 3 or Class 4 part of a building, for lightweight construction required to resist the spread of fire in at least one sole occupancy unit, one of each stair shaft, lift shaft or service shaft of lightweight construction required to resist the spread of fire, the components and junctions of the building elements I just mentioned. Regulation 172 also requires mandatory inspection for one of each type of fire protection method for each type of service penetration that is required to resist the spread of fire or smoke on each story of a Class 2, 3, 4 part, 9A or 9C building. Where the building permit relates to the demolition or removal of a building, the prescribed stages are the completion of precautions for public protection and precautions in accordance with Australian Standard AS 2601, the demolition of structures, under Reg 116 or Reg 117, and final on completion of all demolition or removal work. Where the permit relates to the construction of a swimming pool or spa, the prescribed stages are completion of excavation for the swimming pool or spa before pouring any footing or in situ reinforced concrete member that is specified in the permit, completion of precautions for public protection under Reg 116, such as a temporary swimming pool barrier, final on completion of the swimming pool or spa and related safety barrier. For the construction of a new building or alterations to an existing building, the RBS may omit mandatory notification stages prescribed in Regulation 167 if they are not relevant to the building work under Regulation 170. Otherwise, all prescribed stages must be specified in the building permit and must be inspected. During the construction, the builder named in the building permit after each mandatory notification stage must ensure the RBS is notified that the stage is ready for inspection. Once notification is given, the builder must ensure that no further building work occurs if directed by the RBS. Section 33 of the Act requires that where the relevant building surveyor becomes aware that the builder has not notified them and we're directed to continue to stop a stage, the RBS must notify the VBA. Failure to notify the RBS of a mandatory inspection is an offence under the Act. The VBA are finding that many builders are not meeting their obligations with respect to Section 33 of the Act, in that they are not notifying the RBS they've reached a mandatory notification stage and/or are continuing to undertake the building work when they've been directed by the RBS to stop the work when they reach a mandatory notification stage. If the RBS has not been notified and therefore has not carried out an inspection and the building work has progressed to a point where a final inspection needs to be conducted, the RBS may require the builders to remove or demolish certain parts of the building in order for the RBS or inspector to be able to inspect the work. This could impose substantial costs on the builder and delays to the building project, and also affect the owner who was expecting to have their building handed over at a certain point in time. As discussed in the previous slide, many builders are not meeting their obligations under Section 33 of the Act. The table shown on the slide outlines some statistics from the 2020-2021 year to date, and for the first half of the 2021-2022 year. It can be seen from the number of notifications that referred to the VBA that this issue is quite prevalent in industry. From the total number of Section 33 referrals received by the VBA, it can be seen that there is a distinct increase in the number of referrals in the first half of the 2022 year compared with the number of referrals in the previous year. The VBA strongly encourage builders to ensure that the relevant building surveyor is being notified on reaching a mandatory notification stage for the building work to avoid unnecessary delays, costs to the building projects, and referral for discipline, resulting in fines or other forms of disciplinary action. Section 35 provides a general power for an RBS to cause an inspection of building work at any time, whether a mandatory notification stage has been completed. Accordingly, when assessing a building permit application, the RBS should consider whether any inspections should occur in addition to prescribed mandatory notification stage. The RBS must ensure that all inspections at mandatory notification stages are carried out in person under Section 34 of the Act. The RBS cannot conduct the mandatory inspection relying only on photographs, drones, videos, etc. It's important to note that the RBS must cause an inspection to be carried out in the mandatory notification stage, and it's not appropriate for the builder or the owner to cause a prescribed class of practitioner to carry out an inspection, continue with the work, and then provide certification to the RBS stating the inspection has been passed. Only the RBS may cause this inspection to occur. Pursuant to Section 35A of the Act, the RBS must ensure a record of inspection containing the prescribed information specified in Regulation 173 is made for all inspections carried out under Section 34 or 35 of the Act. It's common practice where the RBS engages a person to inspect on their behalf that they use the person's inspection report or Regulation 126 Certificate of Compliance for building work as a record of inspection. This practice is permissible under the Act. However, the RBS must still ensure that a record contains the prescribed information. RBS must also keep a record of inspections for any inspections carried out with respect to enforcement, and a register must also be kept by the RBS, which includes the prescribed information under Regulation 83 when exercising their powers of entry. Persons who carry out inspections of building work on behalf of an RBS must either be an appropriately registered building surveyor, building inspector, or a prescribed person pursuant to Regulation 174. The inspector can only be engaged by the RBS and must act on behalf of the RBS under their direction. We also encourage the audience to have a look at the VBA quarterly proactive inspection reports on our website, which identifies common issues found by our proactive inspections team to find further areas for improvements. During this presentation, we've discussed the very basics of the application process, documentation requirements, some of the requirements for issuing building permits, and the inspections process, including some insights from the intelligence gathered by the VBA. We hope this has been of assistance to practitioners in providing further understanding and identifying areas where improvements can be made.
Thanks, Christian. I'm sure the attendees found that presentation very valuable. Let's see. Okay. Before we get to the Q&A, I just wanted to pass on some exciting news. The VBA's technical and regulation team will be out on the road in September to go through the proposed changes to the NCC 2022. Currently, the NCC is to be released in October, but stay tuned to the ABC website for any changes. The VBA's roadshow will be visiting 10 regional centres in Victoria and 5 events in Melbourne and Geelong. Visit the VBA website to check out the dates and the locations nearest yourself. Okay. So this brings us to the end of the presentation. And we'll now answer some questions in the remaining time. Again, if we're unable to answer the questions live, we'll provide you with answers at a later date following the presentation. I think we ended up with over 60 questions, which is pretty, there's a fair bit there, Christian. Lots of topics. We had a few questions about performance-based design briefs, council responsibilities. I think most of these questions we're going to have to, spend a bit more time on them than just the next few minutes. One of the questions I'll throw to you is, so are the councils the relevant authority to inform the private building surveyors that there is a dual appointment? So I can take this one. So look, what we would do at the VBA, we would encourage the private building surveyors that they should check in with those clients before accepting an offer of appointment to ensure that there is no other surveyor already appointed to that project. So I don't know if you want to add anything to that, Christian, but
I agree, Dom. I do realise that some councils do actually do this, but I mean, it's not a requirement on councils to do that. They do that of their own volition because they don't want any problems in their municipality, obviously.
Yep. Another one is, can neighbours demand for protection works the relevant documentation, even if the RBS deems it unnecessary? So can they request further info if the RBS says that it's not required?
Well, the answer to that would be no, Dom. As I stated earlier, under Reg 111, protection work is only required where the RBS has determined so under the Form 6.
Okay. Right. And we'll just do one final one. So can a final inspection occur after the completion date of a building permit? Or is it deemed that the building permit has expired upon completion date, therefore the RBS cannot issue the OP or CFI? I think you might have touched on this in the presentation.
I did, thank you, Dom, and thank you for that question, audience. Yeah, I did touch on that in the presentation, and provided all mandatory inspections have been carried out in past and that there's no outstanding directions to fix or notice, directions to fix, should I say, or notices and orders that would prevent the issue of an occupancy permit or certificate of final inspection, then a building permit wouldn't be required if there's no further building work to be carried out. This is because a building permit is issued to carry out building work. It's not just issued for an administrative matter such as issuing an occupancy permit or certificate of final inspection.
Oh, beautiful. Thanks, Christian. Okay, so I think we've just about run out of time, so we'll move on. But so I'd just like to thank everybody for taking the time in joining us today. A recording of this presentation and our feedback survey will be available for you shortly. Make sure you check out the Victorian Building Authority's website for any upcoming for the upcoming roadshow and any further webinars. Anyway, thanks very much and enjoy your afternoon.
Thank you, everyone.